guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Oof. Ugh. Tuesday's my Monday. Ugh. Just yuck. And then there's Wednesday. All right, we're gonna start with Judge Fish for a while, for a bit, and then we're gonna go over to some people who do not consent. Just do not. Here we. I got the whole docket for Judge Fish. It's not long. It's from the 7th and the 10th. Oh, get. Here we go.
7-1. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
Good morning, Ms. Sims.
Good morning.
Were you in court a few minutes ago and I went through some rights with another defendant?
Yes.
Do you believe you understand your rights in this matter?
Yes.
You've been charged here with 2 counts. Count 1, theft, a level 6 felony. The cause states that, dramatic pause, on or about October 25th, 2025 in Porter County, you did knowingly or intentionally exert unauthorized control over Best Buy with the intent to deprive Best Buy of any part of the property's value or use. And the property was valued at least $750,000, but less than $50,000. Do you understand the allegations in count 1?
Yes, sir.
And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes, sir.
And count 2 alleges theft, a class A misdemeanor. This one states that on or about October 25th, 2025 in Porter County, you did knowingly or intentionally exert unauthorized control over property of Best Buy, but it takes away the value of the property, so less than $750, right? Do you understand the allegations in count 2?
Yes, sir.
And a class A misdemeanor carries a possible sentence of up to a year in jail and up to a $5,000 fine. You understand that possible penalty?
Yes, sir.
As required by statute, the court will learn preliminary pleas of not guilty for you on counts 1 and 2. Do you plan to hire a lawyer in this case?
No, sir.
You're not going to hire a lawyer?
No.
You plan to proceed on your own and without counsel, or would you like me to determine whether you qualify for the public defender service?
See if I qualify for a public defender.
Please raise your right hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. And what do you do for work?
I'm in security.
You're a security guard?
Yes.
How much do you earn doing that?
$17.50.
Okay. Where do you live?
Michigan.
And are you buying or renting your home?
Renting.
How much is your rent?
My rent is $15.60, but I have a housing program, so I only pay $480.
You pay how much?
$480.
Does anybody live with you?
My 4 kids.
Did any of them help with any of the bills?
No.
Okay. Do you get any child support or anything?
No, I get SSI.
Or you're on SSI?
My 2 kids are. Well, one of them are right now.
Do you have any other public assistance, food stamps or anything?
Yeah, I get food stamps.
Well, if I do indigent, you qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. I'll set you up for the same dates, except you don't have to come back in 2 weeks.
Okay.
October the 9th at 9 and a pretrial conference on November the 6th at 9. Where do you live in Michigan?
Kalamazoo.
Okay, so that's what, 2 hours away?
Yes.
All right, do you want to appear by Zoom or you want to drive down here?
I'll do Zoom.
Okay, we'll put the Zoom information in the order. You have a phone you can use for Zoom?
Yes, sir.
All right, we'll have you appear by Zoom until your attorney tells you something different.
Okay.
All right, but there'll be the login info, and if you know how to use it, that's all the better. See you back here October the 9th at 9. Yeah, give us a sec. We'll put the Zoom info on this slip for you. I'm going to recess for about 10 minutes. Ms. Spence, you have a matter for Ashley Fagan. State, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Ashley Fagan. Cause number is 64D01 2607F67848. The defendant appears in court in person and with counsel, Ms. Katrina Spence. State of Indiana by Gary Gurman.
Crystal coughed. You can have a seat, ma'am. I just want to make sure you're here. Margaret Lagunas? Risha Wiggs? Okay. So the two of you, I'm going to go through some rights with Ms. Fagan here. I need you to listen to those rights. I'm going to ask you whether you heard them when you come up here. Okay? So please pay attention to this next part. Ms. Fagan, first I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself at any hearing or trial held in this matter. Do you understand those rights as I've just gone through them?
Yes, Your Honor.
And you've been charged here with one count, theft, a level 6 felony. The cause states that on or about July 12th, 2026 in Porter County, you did knowingly or intentionally exert unauthorized control over property of victim 1 with the intent to deprive them of any part of its value or use, and the value of the property was at least $750 but less than $50,000, contrary to statute. They say something about a washer and dryer. Do you understand the allegations in count 1?
Yes, Your Honor.
And is charged with a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, Your Honor.
As required by statute, the court will enter a preliminary plea of not guilty for you on count 1. You have Ms. Spence involved in the case. I'm just going to set you up for a couple of hearings. Just going to use October the 9th and November the 6th. You have those available, counsel? And November 6th. You want them at 9 or 10? Sure. On both? All right. So Ms. Fagan, I'll have you come back on October the 9th at 10 for an omnibus hearing and a pretrial conference on November the 6th at 10. You're ordered to appear for both of those. Do you have any questions?
No, Your Honor. Thank you.
Thank you. We're adjourned. Thanks for your patience this morning. Good day. Crystal Koff, state, would you please set a record?
Yes, thank you, Your Honor. This is State of Indiana versus Crystal Kopp, cause number 64D01-2607F67930. Ms. Kopp appears in court in person without counsel. State of Indiana by Gary German.
Ma'am, were you in court a few minutes ago and I went through some rights with another defendant?
Yes,
And do you believe you understand your rights in this matter?
yes,
You've been charged here with 3 counts. Count 1, possession of methamphetamine, less than 5 grams, a level 6 felony. The cause states that on or about July 14th, 2026 in Porter County, you did knowingly or intentionally, without a valid prescription or doctor's order, possess methamphetamine. You understand the allegations in count 1.
yes,
And a level 6 felony carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
yes,
Count 2 alleges resisting law enforcement, forcibly resisting arrest. A Class A misdemeanor states that on July 14th, 2026 in Porter County, you did knowingly or intentionally forcibly resist, obstruct, or interfere with law enforcement or a person assisting the officer while they were engaged in the execution of their duties, contrary to statute. You understand the allegations in count 2?
yes,
And a Class A misdemeanor carries a possible sentence of up to a year in jail and up to a $5,000 fine. You understand that possible penalty?
yes,
And count 3 says possession of marijuana, a Class B misdemeanor, states that on or about July 14, 2026 in Porter County, you did knowingly or intentionally possess marijuana. You understand the allegations in count 3.
yes,
And a Class B misdemeanor carries a possible sentence of up to 6 months in jail and a $1,000 fine. You understand that possible penalty?
yes.
As required by statute, the court will enter a preliminary plea of not guilty for you on counts 1, 2, and 3. Do you plan to hire a lawyer in this case?
No,
Are you going to proceed on your own without counsel?
No.
Would you like me to see whether you qualify for the public defender
if I
service?
qualify for the public defender.
Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes,
Okay, thank you. And what do you do for work?
I work at Quality Inn, housekeeper,
Okay, and how much do you earn as a housekeeper?
13 an hour,
How many hours a week do you normally get?
maybe 30.
And do you have any other sources of income?
No.
What's your usual take-home pay?
I just got my first check and for 2 weeks it was $560.
Okay. That was after taxes?
Yes.
And you just got the job. What were you doing before that?
I was working at Walgreens.
And when did you leave that employment?
The end of June 22nd, I believe it was.
So a little bit of a gap.
Yeah,
Do you have any money set aside
no,
or saved up?
no,
Are you buying or renting your home?
I'm not. I'm sleeping on a friend's couch right now.
Okay. Are you helping them with any rent?
Yeah, whatever I can.
Okay. You're helping them buy food?
Yeah.
Do you have any kids?
I got 3, but
Lee, thank you so much. I appreciate it. I do. And for the Twitch sub, I appreciate that. Thank you.
they stay with their dad.
Okay. Are you paying child support?
Yes.
Are How much is your child support?
I'm ordered to pay $40 $40 a week.
Okay. Are you on any form of public assistance?
No,
You qualify for public assistance?
I don't know. I just applied for the health coverage.
Okay. You don't have Medicaid yet?
No,
Have you ever been on it?
it's been quite a few years.
Okay. And you're not on food stamps?
No,
Did you apply for food stamps?
not yet.
Do you have a motor vehicle?
I do.
What do you have?
2007 Ford 500.
Do you owe any money on it?
No,
Ford 500?
Mm-hmm.
How many miles are on it?
Almost 300,000,
If you had to sell it today, what do you think you'd put in your pocket?
maybe 800.
$800?
Yeah.
I'll find you indigent. You qualify for the services of the public defender. All the Porter County Public Defender Service to represent you. I'm going to have you come back on October the 9th at 9 for an omnibus hearing and a pretrial conference on November the 6th at 9. You're ordered to appear for both of those dates. Mr. Pribble's phone number is on this sheet as well. You should contact him today.
Okay,
Okay, do you understand?
yes,
All right, we're adjourned. Thank you.
thank you.
Risha Wiggs, state would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana.
My microphone was on. Oh, sorry. Do you hear me yelling at the cats? All these cars.
Raptor, I noticed you
Oops.
you recently in
Oops,
the
oops,
Douglas
oops.
County facilities.
Shh, be quiet. I don't know if you guys just heard that or not. I don't know if you guys hear my cap cut when my YouTube is streaming. Anyway, all these cars are worth $600, $700, $800, but you can't buy a car for $600, $700, and $800 for and it works that you can drive it around. But if you want to sell your car, you're only going to get $600, $700, or $800. I just noticed who you got the membership for. V, you just gave a membership to Bren on Twitch. I'm sure he'll be very thankful for that. All right, back to work.
This is Risha Wiggs. Cause number 64D012607F67988. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
Ms. Wiggs, you were in court a few minutes ago when I went through some rights with another defendant.
Yes, I was.
And do you believe you understand your rights in this matter?
Yes, I do.
All right. You've been charged here with 1 count, theft, a level 6 felony. This cause states that on or about July 15th, 2026 in Porter County, you did knowingly or intentionally exert unauthorized control over property of Ross Dress for Less with the intent to deprive them of any part of its value or use contrary to statute, and that you have a prior unrelated conviction for theft, criminal conversion, robbery, or burglary from LaPorte back in.
Judge, she's just doing what the store told her to do. Ross, Dress for Less. That is less.
2023, where you were just convicted January 5th of 2026. You understand the allegations in count 1.
Yes.
Level 6 felony carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes.
As required by statute, the court will enter a preliminary plea of not guilty for you on count 1. Do you plan to hire a lawyer in this case?
I really don't have the money. I'm on disability.
Okay. You want to see if you qualify for the public defender?
Yes, please.
Please raise your hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth, nothing but the truth?
Yes.
Okay. You're on disability. Is that SSI or DIB?
The DIB, the disability.
How much do you get from it?
Right now, I'm only getting $870 some. I'm paying my own insurance. I'm trying to get that. Medicaid is trying to get it taken care of. I've been struggling for a year to get it. I don't know what's going on.
Okay. You get 870, but it's not SSI. It's DIB.
It's for like, I guess, I don't know if it's SSI. I'm not sure what it is.
Do you get, so normally if your DIB payment is less than the SSI
I don't know.
minimum?
Well, I used to get 11 something. I
used to?
Yes, but I only get 870 something now because of my insurance.
Okay.
Yeah.
And that is insurance for your house?
No, it's for Humana, my health insurance.
Oh, it's health
Medicaid
insurance.
used to pay for it, and that's what I'm working on. They said I was approved as of July. I don't know.
Okay. And where do you live?
I live in Wheatfield.
And are you buying or renting your home?
I just stay with my husband.
Okay, and is your husband buying or renting the home?
He is buying a home.
You buying or renting the home? No, I stay with my husband. What? What do you mean you stay with your husband? That's your home. Are you buying or renting it?
All right, and do you know what your house is worth?
No, because my name's not on it.
How long have you been married?
15 years.
Do you have a prenuptial agreement?
Nope.
So,
Not that I-
so it's your house, ma'am. Whether your name is on it or not means nothing. You had that house for 15 years. Means you paid on that house for 15 years. Means you have plenty of home equity to go get a lawyer.
I'm aware of.
Well, you would have signed it. What size house do you have, ma'am?
It's a 3-bedroom.
And is it like a bi-level?
It's just just a low. It's just one floor.
It's a ranch?
No, it's just a modular.
Okay.
It's
Do you have a basement?
No basement.
Do you know how much the mortgage payment is?
I couldn't tell you. I mean, I think he pays like 800 and some. I'm not sure. He doesn't.
How long have you been working on the mortgage?
He's been doing it for like 8 years or so.
What does he do for a living?
Well, he does concrete. He hasn't worked in the last 2 years because his dad's been sick. So
His what's been sick?
his father, but him and his father used to do concrete together.
Do you have a motor vehicle?
No, I do not.
How do you get around?
He just brings me. He has a vehicle.
She's a
What does he
liar.
have?
He has a 2005
He's a big fat liar. She's just a big fat liar, and she has to realize that no one's believing anything she's saying right now.
Chevy truck.
Does he owe any money on it?
I'm sorry.
Does he owe any money on it?
No, I don't think so.
Do y'all have any kids?
Yes.
Are they in your care and custody?
Yes.
How old are they?
She's 31. She's got Down syndrome.
Okay, you have a disabled child?
Yes.
Are they on Medicaid, Medicare as well?
Yes. Yes, she is.
How does your husband make ends meet?
His
Don't necessarily hate cheating the government, Jude. I don't necessarily hate that. I'm not exactly opposed to it. But she's lying. She's just lying.
dad is helping us. That's
Is your father-in-law willing to hire a lawyer for you?
no. We don't get along.
All right. So one thing I'm curious about is the equity in the house, but I don't really know that information. For now, I'll find you're indigent. You qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. And I'll set you up for the same dates, October the 9th at 9 a.m. for an omnibus hearing, pretrial conference on November the 6th at 9 a.m. You're ordered to appear.
Okay. Thank you.
We'll give you a note. We're adjourned. Margaret Lagunas, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Margaret Lagunas.
Oh dear Lord, we got a Margaret. Where's Margaret? Let's see what Margaret did.
Cause number is 64D01-2607F68079. Defendant appears in court in person without counsel. State of Indiana by Gary Gervin.
Ma'am, first I'm required to advise you of your various rights.
I hear ya, Jim. I do. But the system is a great big scam itself, you know. Taking my money. Oh my gosh, there's too many animals around me. I need someone to come and take these animals away.
In this matter, you have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury. And you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them.
Yes, I do.
You've been charged here with 2 counts. Count 1, theft with a prior conviction, a level 6 felony. The cause states that on or about July 19th, 2026, in Porter County, you did knowingly or intentionally exert unauthorized control over property of Wendy's with the intent to deprive them of any part of the.
Margaret, how dare you steal from Wendy's? What did that sweet little redhead ever do to you?
property's value or use.
Do you have Wendy's in Australia? It's like McDonald's. It's like a burger. It's a fast food place.
And they say that there is a prior conviction for theft, conversion, robbery, or burglary from Porter County from this court back in 2023. Do you understand the allegations in count one?
Yes, I do, Your Honor.
And a level 6 felony carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, Your Honor.
Count 2 alleges unlawful possession of a syringe, a level 6 felony. It states that
Margaret, you also have a syringe? Honey, your life has gone downhill in the last night since I spoke to you last. What are you doing? I wouldn't suggest it. I wouldn't say, oh, you gotta go to Wendy's, it's delicious. I wouldn't.
on or about July 19th, 2026 in Porter County, you did knowingly or intentionally possess or have in your control a hypodermic syringe or instrument adapted for the use of legend drugs, contrary to statute. Do you understand the allegations in count 2?
Yes, I do, Your Honor.
And a level 6 felony carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes, Your Honor.
As required by statute, the court will enter a preliminary plea of not guilty for you on counts 1 and 2. Do you plan to hire a lawyer in this case?
Yes, I am.
You're going to hire
Is it just me, or is all fast food just getting worse and worse and worse? I know it's never been good for you. I'm not saying worse that way. I mean, just the quality of fast food in general. Is it getting worse and worse and worse and worse and worse? It doesn't taste good at all hardly anymore.
private counsel?
Yes, Your Honor.
I'm going to set you for a couple hearings. The first one will be on August 21st, in 2 weeks from today. Come back and let me know what progress you made hiring counsel. The second one's an omnibus hearing. That'll be on October the 9th at 9 a.m. Then a pretrial conference on November the 6th at 9 a.m. in order to appear for both of those, for all 3 of those hearings. You understand?
Yes, Your Honor.
We'll give you a note.
Thank you.
And it's
We're adjourned.
getting way more expensive. It's just as expensive eating at McDonald's as it is to go to a local diner or restaurant. It's just ridiculous. I'm not. I can do Domino's every once in a while, maybe. I cannot do Papa John's. Cannot. Although their garlic sauce that you dip the pizza in, that slaps. That definitely slaps. But I can't eat that pizza. Ugh, no.
Morning, everyone. I'm Judge Mike Fish. Welcome to Porter Superior Court 1. This is our Monday morning high-level felony call. If you're in court for some reason other than a level 4 or 5 felony, you're in the wrong place. You should talk to the security about how they can redirect you. Sammy Glee, state, would you please set a record?
Yes, this will be State of Indiana versus Sammy Glee, 64D01, 2604 at 54550. Defendant appears with counsel attorney Brunhagen. State is represented by Deputy Prosecutor Hammer. We were set today for status.
Yes, sir.
Good morning, Judge. Judge, we are still working through discovery issues. I'd ask to continue the status for about 60 days, and I would accept time for criminal rule 4.
I can go on October the 12th.
Thank you, sir.
I'm going to do it at 11.
11, yes, thank you, Judge.
Objection, state?
No.
Okay. Yeah, Mr. Glee will set your matter over on defense motion to Monday, October the 12th at 11 a.m. You're ordered to appear back here at that date and time. I say thank you.
Call my office.
We're adjourned.
Thank you.
Do you need me to wait? Okay. Did you get that here?
Say her
Troy
name.
Stupek, state, would you please shut her?
We're still trying to figure out if her name is Judy, guys. Is I don't know what she is. Court reporter? Maybe? I don't know.
Record?
This will be State of Indiana versus Troy Stupic, 64D01, 2509 at 59969. Defendant appears with counsel attorney Grunhagen. State's represented by Deputy Prosecutor Hammer. We were set today for status.
Yes, sir.
Judge, Mr. Stupak has a matter in 64 DO4, and there's 4 charges or 5 charges there, Judge. The most serious being operating while intoxicated. My goal is to combine and get a global plea on both this charge as well as that. I'm not sure what the court's feelings are if I file a motion to consolidate that case here. It is, the charges are OWI, endangering, OWI 1.5 or higher, driving while suspended, improper, or no tail, or no turn signal.
I mean, we're not crazy about having Title IX cases here, but we're happy to do it if you want to consolidate it up here.
Okay, I spoke to Mr. Hammer about that. There's, in all candor to the court, there's some charges in Lake County as well. I did discuss a plea offer here, and I wanted to then see where we are vis-a-vis Lake County so we could come up with an agreement that satisfies the court, the state, and Mr. Stupak if we can do that. So I'm going to need a bit more time to get that done, Judge. So I would ask if we could set this to that same 10-12 date, and I will file that motion to have that case then transferred to this court.
Well, I can just pull it up.
Oh, if you can, that would, I think that would be best in this situation.
I'm going to have to buy Jessica an extra piece of cheesecake or something though. I'm not happy.
I appreciate.
We finally found her name. It's not Judy, it's Jessica. Now we know. Maybe she'll pop in chat someday.
The effort.
Yeah.
It's whatever you're allowed to have.
And I would ask for that same 10-12 date.
Low sugar cheesecake. All right. Any objection to the continuance?
No,
You say you don't object to me pulling the case up, right?
no, not at all.
To October 12th?
October 12th at 11, Judge.
All right. We'll see you back here October the 12th at 11, sir. Delays charged to the defendant in your order to appear.
And then I don't have to go to the one on the 20th next week that's here? Or I will have?
Downstairs?
Yes.
You won't have to. That's 10 days from now. We'll pull it up today.
Okay.
Yeah.
Thank you, sir.
Yeah,
Very much.
we'll line those cases up. Are you on pretrial downstairs?
I am not.
You know what I mean? Do you have to report to the probation department?
No.
Are you on supervision in Lake County? Okay, you just bonded out.
Just on bond.
Okay. So that's fine. Salvador Villarreal, say would you please set a record?
Sure.
This will be State of Indiana versus Salvador Villarreal, 64D01-2508 F5 9511. Defendant appears with counsel attorney Grunhagen, states represented by Deputy Prosecutor Hammer. We were set today for status.
Yes, sir.
Judge, we did receive a written plea agreement. Mr. Villarreal is scheduled to come into my office today so that we can discuss that. I will ask for that same 10-12 date, and it's anticipated for change of plea, Judge.
Okay, state, any problem with going out that far?
No.
All right, so we'll set your matter over on defense motion to October the 12th at 11 a.m. You're ordered to appear back here October the 12th at 11. If I don't have a resolution of your case on that day, I will set it for trial. Okay,
Thank you, sir.
thank you, sir.
That's everything I had today.
Appreciate your patience.
Of course.
Gino Miller, state, would you please set a record?
This will be State of Indiana versus Gino Miller, 64D01-2507 F4 7713. Defendant appears with counsel attorney Smithy, states represented by Deputy Prosecutor Hammer. We were set today for status.
Morning, Ms. Smithy.
Good morning, Your Honor.
How can I help?
Your Honor, we are still working on this case. If we could continue this, if the court will allow October 19th, I just said something this morning tentatively for October 12th.
For some reason, I'm not doing October 19th. I'm in trial. Yeah. I can't do the 19th. No. The 5th is wide open and the 26th.
26th? What about the 5th? Is that okay with you? Okay, yeah, the 26th, Your Honor.
Okay. Do you have an offer out? I mean,
We do not, Your Honor. We are still discussing this matter at state. We do not have a plea.
it's just almost going to be, well, it's just a year and like it's 15 months or so. So yeah, I'll decline to put anything in the order this time. State, do you have any objection to going out to the,
No, Your Honor, and the other reason is I believe this was originally Attorney Harper's case, so I think that's played into it a little bit.
did you take the 26th? Is that what you said?
Yes, Your Honor.
October 26th at 11 a.m. In order to appear back here at that date and time, the delay is charged to the defendant.
Thank you, Your Honor.
But I understand the reason for the delay. It just, we need to get the case moving.
Understood, Your Honor. We will get it moving.
Yep, thank you.
Thank you, Your Honor. Okay.
Brent Tomzak, State, would you please set a record?
This will be State of Indiana versus Brent Tomaszak, 64 D01 2511 F5 12709. Defendant appears with Counsel Attorney Smithy, State's represented by Deputy Prosecutor Hammer. We were set today for status as well.
Yes, ma'am.
Your Honor, same thing with this case. We are still working on it. If we could set this for the 26th as well.
Okay, any objection, State?
No, Your Honor.
This one's a little younger, so I'm keen on it. On defense motion, we'll set your case over to October the 26th at 11 a.m. Ready to appear back here October 26th at 11. The delay is charged to the defendant, and we're adjourned. Thank you.
Thank you, Judge.
Okay, that was his docket from the 7th and yesterday. Now let's move to some different courts in Colorado. V, thank you so much for the cheers.
Rapture, I noticed.
Drunken, thank you so much for the gifted membership. How many did you give? Jesus. 5. Wow, that's the biggest ever on Twitch. Someone giving 5 gifted membership is crazy. Who did you get? You got Anna. Yay, thank you so much. I appreciate it. Thank you.
Were you recently in the Douglas County facilities?
Your Honor, Douglas County has me in a catch-22. I made a complaint about their customer service 9119 emergency, and that snowballed into allegations of 1891111E, telephone harassment against these employees. And that further resulted in violations of protection orders because, for whatever reason, I had to call non-emergency numbers. And although I wasn't intentionally
Is there any
trying,
basis for this case?
yes, because it's a violation of protection order.
I want to remind you that you have a right to remain silent. I'm not interested, and I don't think you should be telling me about what did or didn't happen about these charges.
It's not the appropriate time. That's correct, Your Honor.
I
So,
wanted to see, I noticed that we had some indication that you were held in Douglas County. Obviously, you're out.
yeah.
And you posted bond. Thank you for that. Just want to make sure that whatever it is that's happening in Douglas, that you have another court appearance scheduled.
Yeah, everything's
somewhere.
scheduled. Everything's on the up and up, Your Honor.
Just didn't want any confusion with that.
Well, Your Honor, I have a previous case for the same thing here in Arapahoe for violation of protection order that I was bonded out with a PR bond. And then appearing the next time, they used the score, not the relevance that I was appearing in court, and charged me $1,000 bond.
Okay.
And again, I'm going to catch 22, but we'll drop that. I'll follow the paperwork. So what I'd like to do is waive any further reading. I'll apply my Faretto waiver, and let's schedule this for the first court appearance, if we may, please.
Okay, a couple things before we get there.
Yes, sir.
When you filed your bond paperwork, you wrote down an address on, is it Seal Hill?
Sir, that's 9181 East Star Hill Point, Lone Tree, Colorado, 80124. It is my aunt and uncle's address and has been my permanent address since 2001.
That's fine. You just didn't put Lone Tree, Colorado.
Oh, sorry, sir. Yes, sir.
Okay, so
Lone Tree.
That's what I needed for you to do is somewhere go down to the clerk's office and complete that that address.
Okay.
Didn't know where it was. So the other part is that your charges are violation of a protection order, a class 1 misdemeanor, and possession of drug paraphernalia, which is a drug petty offense, comes mainly with a fine, a possibility of a short jail sentence.
That's to do with marijuana, which is technically legal in the state of Colorado. So I'm fine with that, sir.
We're not going to talk about what it was. I'm just telling you what the charge is. I have you down for an arraignment today. Arraignment means you enter a plea of.
Plead not guilty, waive all readings and apply Faretto waiver, Your Honor.
Okay, so to the charge of violation of protection order, what plea do you enter?
Not guilty.
To the charge of possession of drug paraphernalia, what plea do you enter?
Also not guilty, Your Honor.
People are entitled to be represented by a lawyer in any criminal proceeding. You have that right. If you cannot afford an attorney, you can apply for the Colorado State Public Defender's Office. Is it your intention to apply for counsel, or are you going to represent yourself?
Very swiftly, sir, I'm under the impression that the Public Defender's Office was set up by the judicial branch, not the legislative branch. So both the public defender and the judges are beholding to the same purse, which is a violation of separation of powers, and also violates what we would call in the United States a theory of two opposing teams fighting against each other instead of two people combined trying to prosecute people in a corrupt judicial system.
Does that mean you're not going to apply for the public defender?
I am going pro se, sir, and applying my Faretta waiver.
Do you understand that you have a right to be represented by counsel through these proceedings?
I do, Your Honor.
If you cannot afford an attorney and you qualify as indigent under the Colorado Supreme Court guidelines, the court will order the public defender to represent you. You understand that?
What, sir?
If you're indigent,
Oh, yeah, if you apply, yeah, I am not applying, sir, I understand.
I've given you the charges. One's called a violation of protection order. It is a class 1 misdemeanor, could be up to 364 days of jail. The drug paraphernalia is primarily a fine offense, could carry some jail, but it's a fine offense. Do you understand that although you have the right to represent yourself, by doing so, you're taking a great risk of not properly presenting your case?
Sir, I believe I'm taking a greater risk by allowing the public defender who works for the judicial department as legislated by the Colorado Revised Statute on how it's set up. I believe that is the worst risk, sir. And all of these people in custody are taking that.
Are you under the influence of any drug, medication, or alcohol that would affect your understanding of these proceedings?
I am not, Your Honor.
Do you understand that criminal
I hope this guy writes a book someday. Oops. Only visible to me. Nah, it's visible to everybody. It's on my Twitch. It says it's only visible to me. I got a hype chest. I think because Drunken. How do I share it? Okay, everybody can use that now. We have a new emoji. Maybe. Oops, I can't share my own channel. I know, I tried many times. There it is. Drunken, I think you got that for me. Thank you.
law
V, you absolutely helped. Thank you. The gifted. It's because of the gifted subs.
is you probably heard these questions before, haven't you?
Yes, Your Honor.
You know that I have to give them to you.
Yes, Your Honor.
Okay. Do you understand that criminal law is a complicated area that an
So like I was saying, I hope he writes a book someday, this defendant, because I'll read it. I will read it.
attorney trained in this field could be of great help in preparing and representing your defense?
Yes, Your Honor. Lincoln once told a student that it's not who you study with, it's your ability to understand the material, and law should not be ambiguous. However, where do we live? In an ambiguous world with ambiguous law.
We've had 150 years since Lincoln, so we've added some more. Do you have any legal training or education?
I do believe I do, sir.
How many years of formal schooling have you attended?
Post high school, I believe 4 years of college. Did not graduate, got bored.
You know that you have the right to remain silent. Anything that you say concerning your involvement in these charges could be used against you in court.
That is correct, sir. And Maya Angelou says, why does the caged bird sing?
Often wondered that. You have a right to confront witnesses against you and cross-examine them.
That is correct, Your Honor, and that right was taken away from me in Denver. It's Crawford versus Washington. It's called the Confrontation Clause of the Sixth Amendment. I'm very aware of this and how the law is not, or the courtrooms are not, sir. Thank you.
You also have a right to have witnesses you choose compelled to appear and testify on your own behalf. Do you understand that?
Yes, Your Honor.
Do you want to talk with a public defender or any other attorney before you make the decision to waive counsel and represent yourself?
No, Your Honor.
Do you want me to advise you about any matters?
I'd like to waive advisement. Oh, I'm good. Yeah, we're good.
Okay. You have him fill out a form? I just went through the form. You want him to fill it out? Okay. So the court, as you know, whenever one says I'm going to represent themselves, have to go through what's called an Aguelo advisement. I just did that. That's been completed. The court accepts your waiver of counsel, that you're doing it voluntarily, knowingly, and intentionally. So now the court's going to accept your not guilty pleas. Do you want your cases tried by a jury or a judge?
Jury trial, Your Honor.
We're going to give you 2 dates. One is going to be a jury trial date. The next is a trial preparation conference. You may appear by WebEx for the trial prep conference, but you have to make an appearance.
I'll be here in person, Your Honor. Yeah,
Okay.
I'd rather do that.
Dates, please. Jury trial, yep.
December 2nd, so.
Sorry, Seth.
December 2 at 8:15.
Oh, okay, yeah.
And we'll give you these in writing too.
Sure, thank you.
Okay, then the trial preparation conference will be
Pre-trial readiness for that was November 25th. No.
That's kind of close to
Stand by.
Thanksgiving.
Stand by.
Yeah.
At 11 a.m.
Can I get the date? It was a Monday, what? And that's after Thanksgiving holiday weekend? Okay, yeah.
So
Yeah.
it's November 30th. That's the Monday, and then trial is on Wednesday.
Okay, right, yeah.
You understand?
Yes, sir, yeah.
Okay. November 30th at what time? 11 a.m., hopefully after the November stuff that we have like going on here today, the Monday stuff. Sometimes people want to file motions.
Oh, I will.
There's 2 types of motions.
Oh, I will.
Okay. One says, this is a legal argument. It has to do with the court's authority. That's one set.
Procedural or
Procedural.
substantive, yeah.
The other type of motion is one involving the requirement of the district attorney to produce evidence to show something.
That's correct, Your Honor.
Okay, and it just depends on what the motion is. So you're welcome to file either one of those motions. I'm going to give a date for a motion hearing.
Please.
That may or may not involve testimony. It depends on what the motions are. And this is true for the DA too. They may file such motions. So, and we're going to give you a date in which we want you to file the motions. Mainly because if it requires some sort of a testimony, the other side's got to have notice to bring in the
Yes,
witnesses.
I'll have them done in a few days and have them turned in, Your Honor, I promise. I'm very well equipped for this, Your Honor. I used to work for Fiddler's Green, for Fred. He drove an ambulance and I did overnights. So before the concert, it was supposed to be a concert I was at. I saw Fred and reconnected with him after 10 plus years. Then I went inside, purchased food, was sitting down, and somebody treated me very horribly, and I reported that, and I was kicked out of the venue. So what did I do? I called the police and said, you guys are crap. Why do you have this customer service?
Stuff we shouldn't be in.
No, it's good. And so they come and they arrest me and they say whatever. And supposedly I was drinking, but they didn't give me a breathalyzer. There was no blood test and there was no proof. And as far as I know, the Fourth Amendment, probable cause requires more than suspicion. So if cops can just go around and go, oh, I think that guy's drinking and I'm going to lock him up for this and throw him in the thing and, oh, I don't have any evidence. I think that's a huge problem, Your Honor, and I'm here to fix that. And I'm here for all these guys right here and the ladies too. We're sick and tired of this. We're tired of this game.
Get your motions date so you can address that. Date, please.
Justice will be served, Your Honor, and I'm going to serve it.
Wow, sir, you're very smart. You're a smarticle particle. Are you the smartest person in the room? Is that what you're trying to tell us?
I have other court dates too, so let's see, just throw it on there and we'll see what we can do.
October 6th at 2.
Your motions are going to be due by September 8th and responses are going to be due by September 14th.
My motions will be in within days, I promise.
Okay. Good address down at the clerk's office. We'll see you on October 6th.
Your Honor, may I have the speedy trial date, please?
February 10th, 2027.
Thank you.
Your Honor, if you're interested, I have a WordPress blog called American Scheme. I ran into some trouble in California, ended up in Compton, Soledad prison for something I didn't do. last December, I think, Ice Cube came out with a song called American Scheme. People should pay attention. I'll be waiting for the paperwork. Thank you very much.
Thank you for being here. We'll see you in October. Did you get Speedy?
For a pretrial readiness conference, Ms. Velasquez or Mr., who's doing this one? Ms. Velasquez is here for the people. So we have a jury trial scheduled next Tuesday, August 18th at 8:30 a.m. Ms. Velasquez, are the people ready?
Yeah, the people would be announcing ready. I did just want to let the court know that we were having trouble getting the CV for one of the doctors who's endorsed and subbed. I just got an email this morning. It sounds like he was on vacation. He has just provided that CV.
Okay.
So that CV would be late, just given our discovery obligations. But I can provide that to Mr. Stickrod. If he can provide me maybe an email address or something, I can forward specifically the CV to him.
Okay. Mr. Stickrod, are you prepared to go to trial next Tuesday, August 18th at 8:30?
I will be if everybody can just prove to me like you are who you say you are, like proof that you're a government entity. Proof
No,
that you have
I'm not doing that. My question for you, sir,
delegation of authority.
I am not engaging in that type of conversation. My question for you is, are you ready for trial next Tuesday at 8:30? I've got about,
Is this on the record right now?
yeah. And I'll tell you just right now, I've got about, normally these pre-trials take about 5 to 10 minutes. I've got about 15 to address our issues. So we do need to make this somewhat efficient. My question again is, are you ready for trial on next Tuesday at 8:30?
I can be if provided with charters.
If what?
If provided with charters.
With charges?
Charters?
Charters?
Yeah.
Okay. So I'm going to take that as you are ready for trial. And Ms. Velasquez, how long do we think this trial will be?
Yeah, I do think we'll take the full week, so the 4 days that we're currently set for.
Okay.
I don't know how long they'll leave for deliberations for the jury. I think this could be maybe a more complicated issue for them to deliberate on.
Okay.
And so potentially they might be deliberating into the following week.
Okay.
What was that last part?
Deliberating into the following week.
Okay. And then I would also like to,
Okay, hang on 1 second. Hold that thought, Mr. Stickrod, for 1 second. Okay, so 4 days with possible deliberations going into the next week.
Yes, Your Honor. I don't have an extensive amount of witnesses, so I do think that we'll be finishing somewhere around the time frame of Thursday afternoon.
Okay.
Worst case scenario, Friday morning.
Okay, go ahead, Mr. Stickrod, with your comment.
I would like to request a ADA advocate.
An ADA advocate, you would need to make that request through our administration office, which is on the 4th floor of the other side of the building. They handle all of our ADA requests.
Cool.
Yeah.
And how do I access the, what is it, the Supreme Court of Appeals, or how do I appeal to them? Because
I can't give you legal advice on filing appeals.
there's a jurisdictional issue. Because it states that the Supreme Court has original jurisdiction of any case that involves the state.
Okay.
Then there's also one where it says, I'm the state anytime I use my signature, as far as UCC codes go. Which that should work in every court case.
And that's exactly what I call him too, the state. When I talk to this guy on the phone, I'm like, the state, how are you today?
So I don't.
Okay,
I'm confused because I'm just studying law.
Okay, that's fine, Mr. Stickrod, but this isn't about the court proving anything to anybody. It's about presiding over a criminal case where the people have the burden of proving whether you are guilty or not guilty.
Jurisdiction still has to be established.
The court does have jurisdiction. This is a crime that allegedly occurred in El Paso County.
Can't determine that.
So I'm not going to.
The court can't determine its own jurisdiction.
I'm not going to argue with you about this. This is a pretrial readiness conference. And I'm not engaging in a conversation about charters and the UCC and all of that. So we're just determining whether we are ready to go to trial. If you want to do your own independent research on that, you are welcome to do that.
For the record, this is a due process violation.
Okay. We have 4 days.
Sir, I can help you here. There's this last guy that was just on my stream who had a website. If you go to his website and you two put your heads together, oh man, unstoppable.
Days for trial, and okay, so when we select our jury, you will be striking from the presumptive panel. Mr. Stickrod, this is the presumptive panel, so the box is the presumptive panel, meaning that any strike that you exercise will have to be from the box, and then as people get struck, we fill in the empty seats from the people in the back.
What if I remove all planes and boxes?
What?
Remove all planes and boxes, so it's a even playing field?
I don't know what that means.
Then assign you as my fiduciary
You're not
for
going to
the
do
public
that.
trust
Okay. That's not
or whatever. Is that
happening.
a key?
And,
Either way, jurisdiction has to be established before we move forward.
okay, I'm comfortable with the court's jurisdiction. So in my mind, it has been established.
I still don't have your bond. I have your oath. Do you swear by your oath right now?
Sir, I'm not answering these questions. I'm the one in charge of controlling the pretrial
For
readiness.
the
So-
record, will not swear on her own oath.
Okay.
Just saying.
We're going to have one alternate juror, and Mr. Stickrod, do you have, other than your jurisdictional challenge, do you have any evidentiary issues that you want to discuss today for trial?
I still haven't received any body cam footage. Anything that my lawyer had, I've been over there twice.
Okay.
He hasn't answered back, so.
Okay, well, that's certainly a concern because you're saying that you're ready for trial, but you haven't reviewed any of the discovery. So are you sure that you're ready? And it's fine if you still are, but usually folks have reviewed the discovery, so you know how to prepare your cross-examination and put on your evidence and stuff.
Well, my thing is the affidavit that's filed, Vanderpool, I think
Mhm.
her name was. His testimony completely went opposite of what she was saying. And then half that's hearsay, so I'd like to strike down that affidavit and the eyewitness testimony of the officer.
Those would be the types of things that you would raise at trial. I don't just decide in advance unless, especially if it's just that you don't think that the person is testifying consistently with their affidavit, that is impeachment or cross-examination. But my question for you is, not having the body cam and the discovery, do you believe that you are ready to go to trial next week? And if you say yes, that's fine. I'm not suggesting you should answer a certain way. But that could potentially hamstring you in how you prepare the case if you don't have the discovery. And I can order the people to provide you with the discovery this week. So you have it if you don't have it. But you tell me, do you think you're still ready for trial next week?
I mainly wanted my transcripts, but they're trying to charge me a down payment of $450 for them.
Okay, that's not an answer to my question. Do you?
That would make me ready if I had my transcripts, which is also why I wanted the 88. And I figured you'd be able to speed it up if I did it in person here than if I filed the motion through paperwork process.
Do you think you could speak more into the microphone? For some reason, I'm having a little trouble hearing you.
I feel like saying my verbal motion here can make it like grease the wheels to make it move faster for the ADA and all that.
Yeah, the ADA stuff just goes through the ADA people in our admin. They handle all of that.
Okay.
So you could do that
Do they
today.
have y'all's bonds up there too?
No.
Where's that located at?
Sir, I'm not answering these types of questions, okay?
No, it's part of jurisdiction. Like it goes to the oath like peanut butter and jelly. You know, you can't have one without the other, and it doesn't
Okay.
count.
My question for you, and then we're going to move on, and I'm going to take it as you answering ready if you're not giving me a direct answer. Are you ready for trial next week?
I don't understand. I don't consent. I don't contract.
So you're not ready? Are you asking for a continuance?
Until jurisdiction's established, I don't understand.
Okay. Okay, you're not answering my question. So you did answer ready earlier. I've asked, given that you don't have the discovery, if you're ready, and you're not giving me a direct answer. So I will find that both sides are ready. Do you,
I think this whole thing should be void and vacated because
we're going to print off for you the court's trial management order that was filed May 4th of 2026. Sir, that governs other pretrial exchanges that will need to happen before the trial. So if you have proposed jury instructions, things like that, make sure that those are being filed according to my trial management order. Given that this is an F3, I will give each side 40 minutes for voir dire. That is just the amount of time that you will have to question prospective jurors. So 40 minutes for voir dire, that is in the panel or in the trial management order. We've talked about the jury selection, one alternate. Ms. Velasquez, do you have any objection to live streaming?
I have no objection to the live stream, Your Honor.
Okay. Mr. Stickrod, do you have any objection to the court live streaming the trial?
I'm still stuck on jurisdiction.
Okay. Do you have any objection to live streaming?
Are you saying we're not going to establish jurisdiction at this time?
I'm asking you for the third time if you have any objection to live streaming the trial.
I object to moving forward without jurisdiction.
Okay, that's a non-responsive answer. So I will live stream. Please advise your witnesses that sequestration does include live streaming and WebEx.
For the record, nobody has given me any proof of authority
Okay.
whatsoever. What up? To me, y'all are just random people that showed up at my doorstep and took my kids. I need somebody that has a red seal. District 3 court? Is this common law? Is it maritime? Because those are the only two criminal jurisdictions, unless this is my civil case. So, I mean, I just want to know, what are we working with here? Because I didn't commit a crime on the high seas. I mean, jurisdiction isn't just where you did it.
Okay, I disagree with what you're saying.
They haven't even
And
said the
I'm
cause
not,
and nature of it yet.
I'm not requiring the people, the jurisdiction is established by Colorado law, and I'm not engaging in any further
Colorado law does
conversation on
not
that.
supersede the Constitution.
Okay. And sir, if you want to do your own additional research on that to convince yourself that we do or don't have jurisdiction, you're
I'll go
welcome
on
to do
45-minute
that.
rant about it.
And I'd ask that you not speak over me. Okay, so I think I've covered everything that we need to do for the pre-trial readiness conference. Just make sure for the people and for the defense that you are complying with the trial management order in terms of deadlines for filing things. Ms. Velasquez, is there anything else for the people at this time?
No, Your Honor, thank you.
Okay, Mr. Stickrod, anything else?
What are deadlines?
They're in the trial management order.
Is there anything that I missed because I had a lawyer here, and what motions did he file? Because I haven't heard of any.
You're gonna have to look in the court file since you're representing yourself. You can't rely on me to give you legal advice or things like that. We talked about that, but I don't believe that your lawyer had filed any motions. Okay, all right.
Because of my Sorry, I'm a little agitated even before I came up here. My bad. There has to be some way because I've gone to get compensated for my time of doing the lawyer stuff because I'm about to lose everything. And the way my courts are set up, I can't work. I've got two different cases going on right now. Both of them are going to be jury trials. I've been out of work for 6 months because they make us, well, I got fired when I got arrested without a warrant.
What is your request?
Some form of compensation
Denied.
to pay my bills.
Denied. Denied. Okay, so you may visit the fourth floor of the other side of the building if you are requesting some sort of ADA advocate or accommodation. They can help you with that. Otherwise, we will see you back here August 18th at 8:30 for your jury trial. That will be the day that we will be going to trial.
What about my counterclaims? Did you file any of those?
No counterclaims are filed in this case, and it's not a case where counterclaims would be filed. All right, you are released. Thank you. We'll call 25 CR 5622. Michael Kraus was set today for an appearance on an arrest warrant. We have Mr. Finkelstein here for the people. We don't have our public defenders at this point, but we don't have Mr. Kraus. He is in the county jail. He did not come over today. So we will aim for, he also failed to appear July 27th for an appearance of counsel. He's on a no bond hold. We'll set him for next Monday, August 17th at 8:30.
19-117, which governs bail while pending extradition. The court can grant bail. The defense is supposed to give both the judge and the people reasonable notice before asking to address bail. That's subsection 2 of 1619-117. I don't know that that's necessarily been done here. Because if that were the case, I think the people would likely try to obtain some information about that pending Nebraska case so that we can appropriately articulate a bond argument and whether it's appropriate to modify bond at this point. So at this point, the people do object.
Okay. And Ms. Lester, did you give the district attorney notice that you were going to argue this today?
I did not provide Mr. Pomerantz specific information that we would do that in the past. I have relied on 1619-118, where if there is no governor's warrant, the court must continue the matter by addressing bail or extending the time by no more than 60 days.
Right.
There's no notice requirement in that. I have had several extradition cases with Mr. Pomerantz in the past where we have argued bond at this particular review date. But no, I did not provide.
All I needed to know. And you're going under 1619-116 or under 1619-118, did you say?
I cited 1619-118.
Thank you.
It's quiet because the last couple courtrooms, including Judge Fish, was just loud.
Okay. All right. If the accused is not arrested under warrant of the governor by the expiration of the time specified in the warrant or bond, that was the 30 days, a judge of a district court shall either recommit him or her for further period not to exceed 60 days, or again take bail for his or her appearance and surrender as provided in 1619-117, but within a period not to exceed 60 days. All right, so we're going to set it over for 60 days. I'm going to look at 117, 1619-117. Do you have any information for me about what the case is? Is it a felony case in Nebraska?
From his public defender, she said that he pled guilty to attempted possession of LSD, a class 1 misdemeanor. It carries 0 to 1 year in jail, 0 to $1,000 fine. Possession of ketamine, a class 4 felony, carries 0 to 2 years, 0 to $10,000 fine, or 0 to 12 months post-release supervision, and a violation of a protection order, a class 1 misdemeanor, based on the drug possession, 0 to 1 year, 0 to $1,000 fine.
Okay. I am not going to modify the bond today. I think that it would have been good to know about this when he was sentenced in his other cases before me, but we didn't know. And now I'm going to continue the matter for 60 days. What is 60 days from today? Okay.
You want to go past the 60 days or just?
Let's just do 8 weeks, October 6th. How about that for docket? So that is October 6th. At what time?
1 p.m., please.
Okay, at 1 o'clock. And that is for the return of the governor's warrant. All right, anything else from the people?
No, thank you.
Anything else from the defense?
No, thank you.
All right, thanks. Sir, if the warrant comes in earlier than that, of course, we'll vacate the hearing date. Okay, thanks.
I thought, and I was wrong. I thought that guy made a fool of himself in front of the judge, and I was wrong. But fine, we got to hear a nice, quiet case in between the other ones.
Those are the three matters of Isaiah Lytle. 24M3248, 25M3976, and 26M721. Mr. Lytle is appearing this morning in person, represented by Mr. O'Leary. Good morning to you, sir. And I have Mr. Foz on behalf of the people. All right. Let me see. So, Mr. Lytle, I guess you're admitting that you violated probation in 2 matters. And then what's going on with the third? Except for a dispo. Okay.
Right.
All right. So what are we doing on that case?
In that case, we'd like to enter a plea of not guilty and set for a jury trial.
All right. Let's enter a plea of not guilty in 26M721. Speedy trial in that case runs February 10th, 2027. Motions are due 35 days from today, which is September 14th, 2026. Let's get a motions hearing date, jury trial, and a trial call date. Did you want to do the same
It's a
motions
due
hearing
date for me to submit stuff.
Right?
Which day?
Okay. October 9th at 1:30 for the motions hearing. Let's get a jury trial date.
At 1:30, you said?
Yes, sir.
Jury trial December 10th.
December 10th at 8:15 for jury trial. Would you make our trial call? We'll do December 7th at 8:30. All right, Mr. Lytle, it looks like in 25M3976 and 24M3248, you will be admitting that you violated probation. Is that correct?
Yes.
In each of those two cases, you've pled guilty to attempted violation of protection order, class 2 misdemeanor carrying 120 days, and in 3248, you pled guilty to driving after revocation prohibited HTO.
Wait, which one?
24M 3248. What is it? It says,
No.
I apologize, third degree assault. There was a HTO attached to it as well. Third degree assault, which carries a year in jail. Do you understand the penalties related to those two charges?
Yes.
I started 3.5 years ago. So I can't be AI because it wasn't that great back then, or even around.
Do you understand, should you admit, the court has the ability to sentence you to the maximum on each of those charges?
Yes.
Understanding that, do you still wish to admit?
Yes.
I have two documents in front of me entitled advisement for violation of probation. Initial signature is yours.
Yes.
It tells me you reviewed these documents in their entirety, and if you had any questions, your attorney was able to answer those questions. Is that correct?
Correct.
Are you satisfied with that representation?
Yes.
Has anyone forced, threatened, or promised you anything in order to get you to admit today?
No.
Are you under any influence of any drugs, alcohol, or medication?
No.
Do you understand that by admitting, you give up your right to have a hearing to challenge the allegations in each of these two matters?
Yes.
Do you further understand that even if there is an agreement, this court doesn't have to follow that agreement?
Yes.
Do you admit that you violated terms 6 in each of the two complaints?
Yes.
Court will accept the admissions finding they were entered freely, knowingly, voluntarily given after full advisement of rights as well as potential consequences. People, just give me a moment. All right, people, what's your recommendation?
We're recommending that the court adhere to the proposed disposition on the paperwork.
There's
What do we write
nothing
down?
on
I apologize. Hold on. For the 3248 case, we are asking for revoke and terminate with 45 days bail. And then for the 3240, they just both come up the same page?
The other one is 25M 3976.
3976. Hold on. So 25M?
Yeah.
Your Honor, I don't see a current recommendation in the 3976 case, so I will be deferring to the court's discretion.
So that was an attempted violation of protection order, criminal. So I assume you would probably be requesting a jail sentence in that matter as well.
Yes,
Is that
Your
correct?
Honor.
Okay. Defense?
Your Honor, we're asking the court to revoke and reinstate Mr. Lytle in each of these matters. I'll note that that is the recommendation of probation in the complaint dated March 16th of 2026. Really, the only technical violation they allege and that he's admitted to is the missed UAs. They did also note that he hadn't signed up for the domestic violence evaluation and treatment. He has since signed up.
When did he sign up?
He did sign up this past week. So
Wait a second. He's been on probation since when, and he just now signed up?
Right. So There
He's been
were,
on probation since 2025, December 2025, and he's just now signed up last week, August, this in August. Is that what you're telling me?
yes, Your Honor. So in the new report, they did mention they were concerned that like the voucher would expire. I can report that he was able to sign up successfully with the appropriate voucher. So he is getting started with that. Additionally, I'll note that,
Wow, you guys are all coming out today. Josh, Lightfoot, Cloud. It's so nice to see you guys.
on a personal level for him, he has had some significant disruption in his life due to having appendicitis, needing surgery to get his appendix removed. That burst inside of his stomach, and then
When did that occur?
that between now and the last court date on June 17th.
So what's prevented him when he was placed on probation on August 30th, 2024? So we're almost 2 years out from when he was placed on probation in the 24M3248 case where he is third-degree assault, domestic violence against the same victim. What has prevented him from signing up for classes back in 2024?
So ultimately, there's no excuse. At times, there have been issues with the classes being full. That doesn't account for, the entirety of that duration. Given the totality of the circumstances here and the fact that there really is only one, apart from the new law violation, one term alleged to have been violated. And now that he is signed up for these classes, we are requesting revoke and reinstatement. If the court is inclined to impose a sanction, we're asking for in-home detention, which is still beyond what is being recommended by probation.
So probation recommendation that you're referencing is back in March of 2026. But their newest report, August 5th of 2026, indicates on their report that he's still missed 10 UAs. He has submitted 2 that were negative, but other than that, he's still missed 10. And that this officer has no verification as of August 3rd, 2026, that the defendant has scheduled this evaluation. This case has been pending for almost 2 years. So did you see?
I did. I saw creative counseling.
And so, but why now? I guess this question is directed to you, Mr. Lytle, because right now, my intentions right now is to just take you to jail right now because this is a waste of time. You're wasting your time. You're wasting everybody's time. It's 2 years. And on top of that, there's 3 domestic violence cases.
Yes.
2 you've pled guilty to. The third one you've pled not guilty to, which we've set, but I've read it at this stage. And it's childish if this is to be believed. So, Mr. Lytle, tell me why you should not be taken into custody today, because I'm considering 45 days plus 45 days consecutive. So tell me why I shouldn't.
I first want to start off by saying I'm sorry for the charges that I did get, and I do regret all that.
But
I wasn't for
Mr. Lytle, that I don't even need to hear that. That means nothing to me because there's a third case, and the person you should be apologizing to is the victim, Ms. Rodriguez Uribe, who you currently have now 3 cases against. So just focus on what you want me to hear. I don't want to hear all of that, because if you were sorry.
Judge, did you just tell him to break a protection order? Words have meanings, Judge. You're a judge. You can't tell him to go apologize to her.
You wouldn't be here in the first place.
Yes. I wasn't able to apply for the creative treatment earlier. I mean, I was going through a lot in life when I first got on probation.
So why did you agree to do probation in the first place back in 2024?
So that way, I mean, I could try to show you guys that I was able to complete it and do it. I did mess up
like you do know, I just had my son 2 months ago. So, I mean, I'm trying to get my life back on track. I'm trying to get custody of my daughter, shared custody of my daughter. I did go and I did file paperwork.
You filed paperwork? What does that mean?
I filed paperwork to try to be able to do half and half custody of my daughter, Isla. I haven't seen her for a long time.
Is this with the same victim?
Yes, I haven't seen her for.
Whom you have a new case against?
Yeah. And I've been trying to, what's that called? Trying to get the restraining order lifted so that way I could talk to her. I mean, I'm a whole different person now. I'm grown up and I'm just basically trying to get my life together now. With my son coming in this world, I look at things way different, and I'm just basically trying to get everything.
Mr. Lytle, tell me what you're trying to do, because words mean very little over a 2-year period. Just listen to my question.
Okay.
Words mean very little over a 2-year period. It's all about actions, and your actions haven't shown them. So what have you done to get your life back on track?
What I've done is I started off my job as a laborer. I worked my way up to a foreman.
So that means you made more money, which means you should have signed up for your classes. So why did you sign up for classes in 2024?
The job that I have now, which is for groundworks, they haven't really had that much jobs, and they've been asking me to go out of state. But I wasn't able to leave. I didn't really want to leave. That as well. I did sign up for my classes. Like I told you guys that I do want to make amends with Deja, and I don't want any more problems with her. I just want it to be about the kid, our child that we have together. I since haven't contacted her at all. And my daughter's birthday is tomorrow. And I just really want all this to be done and over with. And I did file paperwork to be able to get my daughter at least half and half, so that way everything could go way much more smoother. Like I told you, I just had my son. I take care of him.
Mr. Lytle, as you could probably understand, when people are facing trouble, whether I'm doing misdemeanors or felonies in this courtroom, everyone wants to talk about their children. And just in all due honesty with you, sir, I don't want to hear about your children, because if they were the priority while you've been on probation, you would have focused on just getting your probation done.
Yeah.
And so right now, what your attorney is asking me to do is to put you on probation for another 18 months.
Yes.
And I can tell you right now, oftentimes I will make these offers, and I'm debating on whether it's worth it. And here's the reason why. This is your second revocation on 24M3248. And what I will tell you is, which I probably don't do enough and I probably should do more of, is talking to people about the statistics.
Yes.
After one revocation and you're placed back on probation, your success rate is 14%. Actually, the number has gone down. The success rate is only 12% now. After you've been placed on probation after a second time, the success rate is less than 1%. You're asking to be put on probation for a second time where the success rate is less than 1%. And so as you can imagine, that means that over 99% of the people fail, which these studies have shown it's pointless to put you back on probation. And I got to be honest, I'm really not wanting to put you back on probation. I want you to be a part of your kid's life. And quite frankly, the best route to do that is just to knock this jail sentence out. And no, I would not consider in-home detention, because you've had 3 cases. So against my better judgment, Against my better judgment, here's your offer. Because I was going to give you 90 days. I will give you 45 days of jail, concurrent on both cases. You go into jail today and close these cases out. Or I put you on probation, but if I get the slightest thing missed, you are going to jail for a year plus 120 days. And let me tell you why. This is the same victim 3 times, 3 cases. And you don't, and I need you to understand this because I can almost guarantee you're going to be like, I'll do the probation. But the people who get on this probation, I have only had, and I keep a stat up sheet up here. Out of 17 people that I've put back on probation after this, 1 has been successful. And that one lady, she wore a shirt that said that I'm part of the 1%. They've all have been unsuccessful. And so you may want to have a conversation with your attorney, because if you come back with 1 failed UA or 1 missed UA, you are going to jail for a year. And you're shaking your head, but I don't know if you actually understand the consequences of this. So speak with Mr. O'Leary right now, because I need you to understand I am not playing games with you, Mr. Lytle. You have been in front of me for well over 2 years.
Okay.
So have that conversation.
Okay, thank you.
They were gone for a while, guys. They had a deep conversation. He's coming back. I just didn't cut it close enough. Any second now. There we go.
We're back on the record with Mr. Lytle. What are we doing, Mr. O'Leary?
Your Honor, Mr. Lytle would like to be revoked and reinstated.
All right, Mr. Lytle.
Mr. Lytle, you're a dumbass. Okay. I'm a firm believer in you know, anything you put your mind to do, you can do. You really can, even if only 1% of the people have done it. But not you, sir. Not you. You're a dumbass.
Less than 1%. So you mark my words. So if you come back before me, you already know what's going on. So what the court's going to do under 24M 3248, court's going to revoke your probation for the second time, reinstate your probation for the second time, and final time. You better complete this. 18 months of probation is what it is that you're getting. I will not offer an early termination on this matter because unfortunately you picked up a new case, and I don't know what's going to happen with that case, but you will do the full 18 months. If you come back with one thing, the court will be sentencing you to 1 year in jail. And understand why I'm doing that. I'm doing that because you have 3 cases, 2 cases in which you pled guilty. I haven't gone back to the history to see if there's more than that, but there is the same victim times 3, and that is a concern for this court. If you come back, the court will be sentencing you to 1 year in jail, and parties can make their arguments, but it won't matter at that stage. Under 25M 3976, the court's going to revoke your probation, reinstate your probation with the same terms and conditions. As stated before, 18 months of probation, I'll make it concurrent. Should you come back on probation on this matter revoked, the court will sentence you to 120 days in jail minus any credit for time served that you have on either case. The question, the only argument that the court will listen and entertain at that stage is whether they should be concurrent or consecutive. And I can tell you with the way that these cases were filed, one case was filed in July of 2024. Your second case was filed in July of 2025. So they were a year apart from one another. And then after that July of 2025 case, not even 8 months later, you pick up this new case, 26M 721. And so, Mr. Lytle, it's a heavy burden on your shoulders because a year in jail is a long time. So That'll be the sentence of the court. And I can almost guarantee you the recommendation of the people won't be for 45 days. And I can guarantee you, if you come back to me, it won't be 45 days, which is what you're being offered. And I imagine on a 45-day jail sentence, I imagine you'd probably do, I don't know, 30 days, which would close this case, which would close these cases out permanently, which means you would have no further obligations to the court, no further money to pay to the probation department. But I just want to be sure that you are accepting those terms as to what will occur. Is that correct?
Yes.
All right. Mr. Lytle, I hope not to see you again, sir, at least unless you're coming back to me to say that this matter has been successfully closed. You will report to the probation department today. Immediately, you will head up to the 3rd floor. You will get yourself set up. We will be putting in the minute orders that should you violate probation, you will be facing 1 year of jail in one case and 120 days in the other case. That's what the minute orders will indicate, because I have thousands of cases and so I don't remember everything. But that'll be in the minute orders here. And the court doesn't believe in 100%, zero tolerance. I don't believe in that. I believe in absolute best efforts. And what you've done has not been best efforts. To sign up for domestic violence classes last week is not best efforts by any stretch of the imagination. So there you go, Mr. Lytle. Mr. O'Leary, anything additional, sir?
Your Honor, we would like to address the protection orders.
I am not addressing these protection orders today. He has not proven himself to be worthy of being able to handle these matters when the fact that he picked up a 3rd case. But I will address your protection orders on.
I can't have a follow-up video. This was yesterday. This was a couple hours ago. He's probably already reoffended. Your Honor, I want to address the protection order. Dumbass. Have you not been paying attention to anything at all that has just happened? I wonder if his lawyer was like, listen, take the probation. I'll fix the protection order for you.
That's too far away. I'll address them on September. Let's do September 16th. People, I understand the defense asked to address the protection orders, but VRA is in your court. So let me ask, was there a request by the victim with respect to the protection orders?
Let me take a look. The last contact we've had with the victim was in 2025, and they asked to have no modifications to the protection order. So we'd have to read VRA at this time.
All right. Well, people are not VRA compliant at this stage. September 16th, 8:30. Mr. Lytle, if you want to address the protection order, you can come back on that date. I'll give the people an opportunity till September 16th in order to become VRA compliant as well. I can tell you right now, I'm probably going to put in a Jasper order on the 3rd case, 26M721. So the minute order will indicate the Jasper order will be October 9th. Will be the Jasper order entered at that stage. All right. If there's nothing additional, we'll be in a recess. We'll see the parties. Hopefully, we won't see the parties except on the one case. Good luck to you, Mr. Lytle.
So just one further record on the protection order. We have sought to modify it previously. The main modification we are seeking is electronic and in public communication for parenting purposes pursuant to Mr. Lytle's constitutional right to parent.
I would be happy to grant that, potentially, probably with some additional restrictions, but I need them to be VRA compliant. So when they're VRA compliant, if you want, and you're in communication with them, if they want to file something prior to September 16th, I'm happy to address that as well.
At 8:30?
Yes, sir. And yes, y'all know me, so let's not make any secret of it. I believe that every person should be able to parent their child. I consider that the highest calling. I just don't take too kindly to people talking to me about their children when they're not complying with probation. So, but I'm happy to address that, and I'm happy to grant that to you, Mr. Lytle, because I think you should be in the life of your child. However, you also need to be in compliance with the court orders as well. So people can become VRA compliant. I'm not rushing you. September 16th is the date, but if you get it done sooner, we'll address it sooner. All right, we'll be at recess.
Well, that sucks. My stream's over. That means I have to start this week. Oh, I'm dreading this week. It's going to be a bear of a week, guys. I told you that before, but there's some new people here today. I work a lot this week, so we're going to do some premieres this week. There's no other way around it. Thank you so much for coming out. I really, really, really appreciate it. Take time to be nice to someone this week, please, guys. I'll see you all tomorrow morning, but I probably won't. Maybe I'll find a way to get into chat if I can wake up. Have a good day, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.